18, the chairman cum appellate authority versus Meena Pratap for the appellant Sri Satyabir Bharti.
May it please, Your Lordship. It is a case of departmental proceeding. The writ petitioner, original writ petitioner was dismissed from service, and during the pendency of the writ petition he had died, and therefore his legal heirs had been substituted, and thereafter judgment was passed by the learned single allowing the writ petition. The order of dismissal was set aside, and it was not remanded because he had died, and all back wages and all those things were directed to have be paid to the.
So it has become infructuous.
Lordships, we are in appeal, Your Lordship.
Huh?
We are in appeal. BPSC, he was an employee of the Bihar Public Service Commission.
All right, give the dates and events from the date of charge memo.
Lordships, I have got some date, but I could not prepare date according to Lordships because I just saw.
No, that is that's all right.
But I have got
but
some dates.
But you can give, no?
Yeah. Lordships, he was initially suspended.
No, what was the post held by the Banu?
He was
Banu Pratap.
Petitioner was an analyst programmer. Programmer in the office of the Bihar Public Service Commission.
Charge memo was issued on what date?
Charge memo was issued on, Your Lordship's 3rd of May 2012.
What is the date of his explanation?
Lordship's date of explanation. That is, he has perhaps not enclosed in the writ petition, but inquiry report date, Your Lordship.
What is the date of inquiry report?
30th of August 2012.
August 2012.
Lordship.
Second show cause notice?
Second show cause notice was issued on 21st of September 2012.
2012? 12. His explanation?
Dismissal was
explanation.
Second show cause.
That is on 25th October 2012.
October 2000?
Yes.
12.
25th October 2012.
Penalty of dismissal or removal?
Dismissal, Your Lordship. 18th of March 2013.
18th March?
2013.
Was there any appeal?
He went in appeal, Lordship. The appeal was dismissed on 14th of November 2013.
No revision?
No revision.
What is the date of death of the deceased employee?
That is, Your Lordship, 23rd October 2017.
23rd October 2017. Yes, on what ground the learned single judge has interfered?
Lordship's learned single judge has allowed the writ petitions on 3 grounds. Number 1, he says that the charges were vague and inadequate.
Charges?
Were vague and inadequate. Second reason which the learned single judge has assigned is that the reply of the petitioner against the charges was to be considered by the disciplinary authority and not by the inquiry officer.
The third ground?
And third ground that the entire evidence is entire material which was relied upon is only the vigilance report. Vigilance report. And the evidence given by the vigilance department.
What is wrong with that? If the vigilance report is given evidence, what is wrong with that?
That's nothing wrong, Your Lordship. And apart from that, we are saying that there were independent other witnesses also, and independent material
What is the
also.
charge? Where is the charge memo?
Lots. Charge memo is annexure 1 to the writ petition. And in fact, your lordship will see there is an English translation of the charges in the judgment also, which would be convenient to my lords.
No, I think it is in English only, page 83.
Lordship. Yes, your lordship, page 18 only. That is the English translation. If your lordship will
Where
see
is the charge?
Lordship. Charge number 1, paragraph 13. I'll place the charge. Para 13, your lordship, of the judgment, your lordship, page 18. Your lordship, page 5 of the judgment. Lordship.
No, where is charge extracted?
Charge. Original charge is in Hindi, which is annexure 1 to the writ petition.
Just after this. Just after this. Just after this.
Read the charge.
Lordship. Originally, Lordship, 10 charges were framed, but the appellate authority finally dismissed him on 3 charges: charge 1, charge 2, and charge 9.
All right.
Lordship.
Read
Lordship.
the approved charge.
Lordship, I am just reading the proof. Charge number 1, paragraph 13 of the judgment. This is an
Yes.
English translation of the charges. Charge to keep OMR sheet in custody of a lower grade employee in an arbitrary manner. And then the statement of imputation is there. The OMR answer sheet of the first Bihar Administrative Service Examination 2003, advertisement number so and so, were scanned by you with the help of Vijay Kumar, analyst programmer, and Sanjeev Kumar, information officer. And after preparing a database, the result was prepared in the computer section of the commission on the basis of model answer made available by the commission. Then next page, your lordship. The answer sheet of the candidates pertaining to the said advertisement were kept unnecessarily in the computer section under the custody of Shri Satyendra Kumar Chaudhary, a lower grade employee of the computer section, till publication of result in your knowledge and with your consent, where the result was prepared under your supervision. On the basis of the said act committed by you, a charge of making meritorious candidates unsuccessful and less meritorious candidates successful by indulging in corrupt practice is made out.
No, who has tampered the answer script?
Lordship, petitioner, writ petitioner. He
Wait.
was the analyst programmer.
No.
He was this was an OMR sheet. Answers were in OMR sheet. Commission. He was the analyst programmer. He was the in charge of the section wherein he was required to scan.
Where are the instructions given to the analyst?
Lordship.
That his function is this in respect of competitive exam.
That has come in the inquiry report, your lordship. That has come in the inquiry report.
That is part and that is a list of documents. Where is the list of documents in support of first charge?
So far as list of document, as per the memo of charge, only 2 documents were there. One is the advertisement, and second was Anusansa ki prati, that is the recommendation, and third was Anusandhan ki prati, that is the investigation report.
How can it be? It has to be proved with reference to his function, no?
Yes.
Now his allegation charge is that he has kept the records relating to this OMR whatever data entry with one Satyendra Kumar Chaudhary, who was a lower grade employee. In order to overcome that, he must keep himself What is the material you are relying on?
Lordship,
Where is the powers and functions assigned to the?
yes, in the inquiry report it has come that he was made the in charge of this entire scanning
No,
process.
sir. So and so ABCD work has been assigned to the deceased employee. Where is that in respect of this OMR?
Lordship.
So as to contend that he has entrusted the matter or made custodian of those records to
Yes.
Satyendra Kumar Chaudhary.
That letter is not on record, Your Lordship, in this proceeding.
Then without that, how are you going to prove?
But those letters were relied upon by the inquiry officer to prove the charge against him.
Then you show me how the inquiring authority has proved that
Lord.
the deceased employee
Yes.
was not supposed to
Yes.
hand over the papers to Satyendra
Yes.
Kumar Chaudhary.
Lordship will see page 59 is the inquiry report
59.
of the writ petition.
Show me the relevant portion that so and so work is entrusted to you. You can't subdelegate the work.
Lordship, page 60, Lordship may come. Lordship, it is in Hindi. I'll just try to translate it for you. फर्स्ट पैराग्राफ, वेरी फर्स्ट पैराग्राफ, आरोपी पदाधिकारी ने परीक्षा फल तैयार करने के संबंध में अपना स्पष्टीकरण में कुछ नहीं लिखा है, लेकिन उनके स्पष्टीकरण के साथ एनेक्सर 2 आयोग कार्यालय का आदेश, दिस इज द ऑर्डर ऑफ द कमीशन डेटेड 7th of December 2020, in which it has been directed as under
7th December
2000 Your Lordship.
2000.
Lordship.
This is cited as a document in the list of documents.
Lordship, he has cited as annexure 2. That is the order of the commission by which he has been assigned this evaluation
No,
work.
sir. In the inquiry, the
This-
charge memo,
Yeah.
this 710 12 2000
No,
is
charge
there.
memo, this is not
Then you
mentioned. But he has referred this document, which was discussed by the inquiry
That
officer.
means extraneous material is being taken into consideration.
But the writ petitioner has himself brought this document on record, Your Lordship.
Maybe, but in
therefore-
order to prove
Lordship,
that you are assigned these many functions,
Lordship.
but you have violated that, you are not produced this document at all in order to fasten liability on the petitioner, deceased employee.
But Lordship, this is in the inquiry proceeding, he had appeared all those.
Sir, that is a different aspect, sir.
Lordship.
You have taken into consideration extraneous material, which is not permissible.
Lordship, it is not his plea that documents have been relied upon behind his back, and which has been made a basis for his.
No, sir. What is the object of providing the list of documents? Only these documents will be taken into consideration
Yes.
for the purpose of holding inquiry.
Yes, Lordship.
So, if whatever beyond that, for example, A, B, C, D, E, 5 documents are cited as a list of documents. Can you take beyond 5 documents?
Lordship.
For that, you must make him an availability of the document if you are relying on additional document. In advance, you have to provide a copy during the process of inquiry. And charge is that he has handed over the papers to his subordinate.
Yes.
So for that, you have to prove, no, that the charge employee should not hand over to he himself should be the custodian of the records.
Lordship, this document which was referred to during the entire inquiry proceeding, Your Lordship.
Sir, extraneous material cannot be taken into consideration.
Agreed, Your Lordship, but this document was to the knowledge of the petitioner.
No,
Petitioner
knowledge is different.
Petitioner-
Then what is the object of providing a list of
object
documents?
is, Lordship, that there should not be any document should not be relied upon which should take the this delinquent by surprise. He should not be taken by surprise. He should be given an opportunity to rebut those documents.
No.
or to explain.
Have you amended the list of documents in the charge memo?
Lordships. No, those materials are not there, Lordships. But Lordships, there is
Anything else?
no violation of principles of natural justice because he was aware of those documents and
Sir,
he
you
had relied
can't
upon.
can't presume things. He is aware of that.
No, he had himself
Sir,
relied upon.
you yourself charged him.
Lordship.
You should have included this 7/12/2000 document as additional document after amending the
But
charge
Your
memo.
Lordship, the learned single judge is saying that the charges were vague. Charges were very specific, it was not at all vague, Your Lordship.
No, charge is very vague. Only thing is we have to take shelter under the statement of imputation.
Lordship.
That is
Yes, yes.
permissible.
Yes.
In the statement of imputation, details are come.
They are, Your Lordship.
They are
they
there. But
yes.
extraneous material cannot be taken.
And then, Lordship, the second ground learned single is saying that the charge, the
that the
defense has to.
yes, that is correct. See, article of charges were issued to an
Lordship.
employee seeking explanation.
Lordship.
On receipt of his explanation, disciplinary authority has to take a decision that his explanation is not satisfactory. Therefore, I am going to appoint inquiring officer and presenting officer. In that event, how inquiring officer will take a decision? In other words, what has happened is disciplinary authority, before acceptance of the, before examining the explanation of the petitioner, he has appointed the inquiring officer. How is it permissible?
Lordship, here I beg to differ, Your Lordship, because under the CCA rules, there is no such provision that before appointing an inquiry officer or before proceeding
So
with
you
the,
mean to say it is only an empty formality?
No, it is not a Lordship. The provision is that after framing of charge, an explanation is sought from the delinquent officer or the employee, and if the disciplinary authority thinks that he will himself inquire into the charges, he may do so. But if it thinks that an inquiry officer should be appointed, then he will refer it to the inquiry officer.
No,
but
if your argument is accepted, if your
Lordship.
argument is accepted,
Lordship.
then it is only empty formality.
No,
I
it
will
is-
issue charge memo, you file your explanation, I will appoint inquiring officer.
I can there is an inquiry, full-fledged inquiry on the charges, whether the charges should is proved to be said to be proved against him or not, or whether he has
No,
committed
that is a
any
different
default.
aspect.
That
now,
is the
now we are in the
but
intervening period.
intervening period, that there should be a prima facie case made out like
Where
a
is
stage
that,
of cognizance.
where is such recording by the disciplinary authority?
That is my submission. There is no requirement in law for that recording of that submission, because that is the sections rule 17 of the CCA rules. It says that you ask for the charges, you frame the charges, ask for an explanation from him, and you may yourself inquire into the charges or appoint an inquiry officer to examine the charges against him. But there is no provision that before going to the next step, you should record your satisfaction that whether a prima facie case is made out or not, because that's
All right, now charge number 1 is extraneous material is taken into consideration. What about the other two charges which were
Lordship. Next charge, Your Lordship may find at internal page 8 of the judgment. Internal page 8.
charge number 2 is proved.
Lordship, it is proved, Your Lordship.
Read the charge.
Lordship, I am just placing it. Charge removal of the data of second paper from the computer. Statement of fact. It was found during investigation that the data of the second paper were removed from the computer without the order of the competent authority. It was also found that in the case of leaving entire OMR sheet blank by the candidates or filing 3 alternative boxes against one, and the same question the related answer sheet was said to have been read by the computer. As such, answer sheet of many candidates who were found fit by the petitioner after scanning were not proper, and the said candidate should not have been selected. The answer sheet should have been carefully examined. Any error should have been placed before the competent authority, but you did not do so, which shows your wrong intention.
And who is the investigating officer?
Evidence, Lordship, for the second charge is the copy of the NIC report.
All right.
NIC had reported that the
NIC is the
National
investigating authority.
NIC, National Informatic Computer Center.
No, they are the investigating authority.
No, they are not. The Vigilance Department had conducted. This was a criminal case was in fact lodged.
No, sir. Who is the investigating authority?
Vigilance Department.
Has he been examined?
No, vigilance officer has not been. But
No,
so
no
far as
examination
charge, so far as charge 2 is concerned, the basis of charge 2 was report of the NIC, that is National Informatic Computers Lordship.
Yeah,
They reported that
no,
they had,
NIC, author of report of NIC has been examined.
yes, NIC report was there, Your Lordship. That was the evidence,
NIC report is with reference to the investigation report.
Lordship, with respect to
So
that.
investigation officer has not been examined.
Investigation officer has not been. There was no witnesses as such, or it was based on documentary evidence only entire.
No, correct, but the second charge is based on NIC report.
Yeah, NIC report.
NIC report is based on the investigation report, investigation officer.
It was in continuation of the investigation which
So
was carried out.
investigating authority has not been examined. Next charge.
Next charge, Your Lordship will find at page 10,
Charge number 9.
charge number 9. This to make changes in the qualifying marks. Statement: the candidate of the advertisement number so and so Bihar Administrative Service Limited examination 2003 were needed to obtain 40% marks with a provision to a relaxation of 5% for the candidates of scheduled caste, scheduled tribe, but in a deliberate manner for personal gain you have made the roll number so and so selected despite having marks less than the qualifying marks, whereas no communique was published for change in qualifying marks. Vigilance Investigation Bureau had charged you for conspiracy for personal gain, and the same was held to be correct in investigation. Evidence is investigation report by vigilance.
Same thing. Investigating officer has not been examined.
Officer has not been examined. His report has been made the basis, Your Lordship.
Yes. That's all.
That's all.
Please take down. Instant appeal is by the BPSC, sorry, Bihar Public Service Commission, within bracket for short, BPSC. The appellants have questioned the validity of order of the learned single judge dated 29/6/2018, passed in CWJC 7006 of 2014. First, deceased Banu Pratap, who was working as an analyst programmer with the appellants, was subjected to disciplinary proceedings. What happened to the criminal case?
Lordship, we
Abated.
are not aware. Obviously, since he has died, Your Lordship,
Abated.
Abated, Your Lordship.
He was subjected to parallel proceedings.
Very good.
In the disciplinary proceedings, it was concluded in imposition of penalty of dismissal from service on 18/3/2013. Full stop. In the criminal proceedings, it is stated to have attained, stated to have abated on account of death of the deceased employee on 23/10/2017. Full stop. Thus, the legal heir of the deceased employee Banu Pratap have come on record in the writ petition. Full stop. Next paragraph. Deceased employee was charge sheeted on 3/5/2012. On 13 charges.
Lordship, 10 charges. 10 charges.
10 charges. Full stop. He is stated to have submitted his explanation. Full stop. Disciplinary authority was not satisfied with the explanation and proceeded to appoint inquiring officer and presenting officer to stop. The inquiring officer submitted his report on 30th August 2012. While holding charge number 1, 2 and 9 were proved, the remaining charges were not proved. To stop. On receipt of inquiring officer's report, the DCP authority issued a second show cause notice on 21/9/2012, for which the deceased employee is stated to have submitted explanation on 25/10/2012. To stop. Based on these material information, the DCP authority proceeded to impose the penalty of dismissal from service on 18/3/2013. To stop. Deceased employee, feeling aggrieved by the order of penalty of dismissal, preferred appeal, and it was rejected on 14/11/2013. Thus, a deceased employee preferred CWJC 7006 of 2014. To stop. Next paragraph. On 29/6/2018, learned single judge allowed the CWJC 7006 of 2014. Thus, the present appeal by the BPSC. To stop. Next paragraph. Learned counsel for the BPSC vehemently contended that learned single judge has committed error in holding that the charges leveled against the deceased employee are vague and inadequate. To stop. It is further submitted that the explanation / reply to the charge memo was examined by the inquiring officer instead of DCP authority. To stop. Further, the vigilance report is not in terms of the relevant provisions. To stop. The aforesaid reasoning by the learned single judge is incorrect, having regard to the material on facts. To stop. It is submitted that even though charge is vague, at the same time statement of imputation provides all material, all ingredients in respect of charge. To stop. It is further submitted that on receipt of deceased employee's explanation to the charge memo, there is no mandatory provision that the DCP authority is required to examine the explanation and pass any order. To stop. If the DCP authority feels that it is a case for inquiry, he can order for inquiry. Thus, inquiry has been ordered. To stop. In respect of vigilance report is concerned, there is no infirmity, and it is by competent authority. In the light of these facts and circumstances, order of the learned single judge dated so and so, passed in so and so, is liable to be set aside. To stop. Per contra, learned counsel for the respondent resisted the aforesaid contention of the BPSC standing counsel and submitted that there is no infirmity in the order of the learned single judge. To stop. It is further submitted that relevant document have not been relied on, have not been cited in the list of documents, namely 7/12/2000 communication in respect of functioning of the analyst programmer with reference to competitive examination, like how to maintain OMR sheets and other material information. In the absence of citing 712-2000 document in the list of documents in the charge along with the charge memo, it amounts to relying on extraneous material to stop. Even though deceased employee was aware of the powers and functions assigned to him, at the same time, when the charge is that the deceased employee had acted contrary to 712-2000 to the extent that materials have been given to his subordinate employee, namely Satyendra Kumar Chaudhary, as a custodian of the records. To stop. In order to prove that deceased employee was assigned certain functions, the relevant document is 712-2000 and it was not part and parcel of the inquiry proceedings. So it is further submitted that relevant witnesses have not been examined in support of the proved charge number 1, 2 and 9. Stop. Therefore, there is no infirmity in the order of the learned single judge heard the learned counsels for the respective parties. Undisputed facts are that the deceased employee who was working as an analyst programmer with the BPSC was subjected to disciplinary proceedings in the framing article of charges 10 in number on 3/5/2012, and it was concluded in imposition of penalty of dismissal from service. Further, deceased employee suffered order before the appellate authority on 14/11/2013 to stop. Next paragraph. No doubt, the learned single judge has committed error while assigning the reasons that the charge is vague and inadequate. There is a non-examination of deceased employees' explanation/reply to the charge memo by the disciplinary authority, and vigilance report is not in accordance with the relevant provision. However, it is to be taken note of that the charge number 1 is proved. In respect of proving the charge number 1, relevant document has not been cited, like what are the powers and functions assigned to the deceased analyst programmer, so as to contend that he has violated instructions given to him by his superiors. Even though such instructions were given by communication dated 7/12/2000, at the same time it was not cited as one of the document along with the charge memo. In other words, extraneous material has been taken into consideration for the purpose of proving charge number 1, and it is not permissible. In fact, disciplinary authority could have issued amended charge memo while incorporating additional document, the additional document, namely communication dated 7/12/2000. Further, the author of 7/12/2000 document as a witness in the absence of citing the communication dated 7/12/2000 and examination and cross-examination of the author of the communication dated 7/12/2000, proving the charge is beyond the scope of present inquiry. Full stop. Next paragraph. Charge number 2. 2 is based on the NIC report. Full stop. Author of NIC report was examined. At the same time, it was noticed that NIC report is based on the investigating officer's report. Full stop. Investigating officer has not been cited as a witness so as to examine and cross-examine. Full stop. The entire NIC report is based on the investigating officer's report. The very the very author of the investigating officer has not been cited and cross-examined. Therefore, to the above extent, charge number 2 cannot be held as proved. Full stop. Next paragraph. Charge number 9 is concerned. It is to be noted that it is in respect of it is proved with reference to the investigation report. Full stop. As noticed earlier, the investigating officer has not been cited, has not been examined, has not been cited as one of the witness in support of charge number 9, and he has not been examined and cross-examined. Full stop. Next paragraph. Apex Court in the case of UCO Bank versus SC Giryotra held that if in an inquiry, if any document is to be relied on, in such an event, author of the document is required to be examined. Full stop. That apart, non-citing relevant documents and non-citing a relevant witness in order to prove charge number 1, 2 and 9, the appellants have not made out a case, even though reasoning assigned by the single judge may not be correct. At the same time, in view of the aforesaid lacuna, the appellants have not made out a case so as to interfere with the order of dismissal dated 18/3/2013 and appellate authorities order dated 14/11/2013. Full stop. The observation made by the single judge would not come in the way of the present order. Accordingly, the appeal stands dismissed.